Hi, a quick note before we get started. Minimum Competence now offers CLE courses. Our first course is live and it's completely free. It covers researching federal tax issues after the Supreme Court's decision in Loper, including how the end of Chevron deference changes the way lawyers should approach Treasury regulations, IRS guidance, and tax research more generally. I think it's interesting for a more broad audience, and if you need CLE credit or you're just interested in the topic, head over to cle.minimumcomp.com. Again, the course is free, and you can find it at cle.minimumcomp.com. All right, on to today's episode. Hello and welcome to the Minimum Competence episode for Monday, August 24th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, a judge vacates the 75-country immigrant visa ban, Golden Gate Bridge protesters get 30 days instead of 5 years, and TikTok pays $400 million over children's privacy. Let's remember, the right to think as you will and to speak what you think are means indispensable to the discovery and spread of political truth. And read today's legal news. On this day in legal history, August 24th, 1954, President Dwight Eisenhower signed the Communist Control Act, a law that did something extraordinary in a country built around the First Amendment. It effectively outlawed a political party. The act declared the Communist Party of the United States an instrument of a conspiracy to overthrow the government. It stripped it of all rights, privileges, and immunities available to legal organizations and made knowing membership in the party potentially criminal. Perhaps more remarkable is how little resistance any of this encountered. This was the height of the McCarthy era, when the political cost of appearing insufficiently hostile to communism was enormous. The bill passed the Senate 79-0 and the House 265-2. Those margins tell you something important about the moment. Liberals and conservatives alike had strong incentives to demonstrate their anti-communist bona fides, and almost no one had much incentive to be the person standing up for the constitutional rights of communists. Eisenhower signed the bill, and, at least on paper, an American political party ceased to have any legal existence. The significance of August 24th, 1954 is mostly as a lesson in what happens to civil liberties when they're placed under enough political pressure, and in the messier ways our constitutional system often corrects itself. The Communist Control Act was constitutionally dubious from the start. Punishing someone for just belonging to a political organization runs directly into the freedoms of speech and association. But the law was rarely enforced. Courts largely avoided confronting its most sweeping provisions head on, and it gradually withered into a stricture approaching a dead letter, though it technically remains on the books. Later Supreme Court decisions made considerably clearer that the government can't punish mere association or abstract advocacy, as opposed to incitement to imminent lawless action. That makes this a fitting anniversary for a day when we also have a story about protesters sentenced for their political activity. The point captured in today's opening quote from Justice Brandeis is easy to endorse when the speaker and the cause are popular. The real test of the freedom to think and speak as you will comes when neither is. A federal judge has struck down one of the administration's broader immigration policies, vacating a State Department decision that suspended immigrant visa processing for applicants from 75 countries. The policy, announced in January, halted immigrant visa processing for nationals of 75 countries, including Afghanistan, Iran, Russia, and Somalia, on the theory that applicants from those countries were likely to require public assistance. U.S. District Judge Yanette Vargas in Manhattan called the policy patently unlawful, but the interesting part of the decision is less the rhetoric than the relatively straightforward statutory problem she identified. Secretary of State Marco Rubio did not have the power Congress gave someone else. Federal immigration law expressly limits the Secretary of State's authority over how consular officers process immigrant visas. The administration therefore could not use the Secretary's general authority to accomplish something Congress had specifically placed beyond his reach. It is a theme we have seen repeatedly this summer. Not some enormous constitutional confrontation over presidential power, but the considerably more mundane question of whether the executive branch can point to a statute that actually authorizes what it is doing. Vargas's order also does more than stop the policy going forward. She vacated visa denials based solely on the suspended processing policy, meaning applicants who were turned away under it can have their applications reconsidered. The lawsuit was brought by immigrant rights organizations, visa applicants, and U.S. citizens seeking visas for family members. The broader point is that immigration and foreign affairs may be areas in which the executive branch enjoys substantial discretion, but discretion is not the same thing as unlimited authority. The government still needs to identify where Congress gave it the power it claims to possess. Here, the court concluded Congress had done essentially the opposite. 7 pro-Palestinian protesters who shut down the Golden Gate Bridge in 2024 have now been sentenced, and the result is a useful little illustration of how the law handles civil disobedience. The 7 were among 26 protesters who drove onto the bridge in April of 2024, stopped their vehicles, and chained themselves together to protest the war in Gaza, blocking traffic for hours. They were convicted in July of misdemeanor false imprisonment, obstruction of a thoroughfare, and unlawful assembly. On Friday, they were sentenced to 30 days in jail with an option that could cut that time in half, along with 6 months of probation and roughly $1,000 in fines and restitution. The First Amendment line here is not especially mysterious. Protest is protected. Physically preventing other people from leaving is not. That is the significance of the false imprisonment charge. Motorists were stuck on a bridge with nowhere else to go. You can stand alongside the road holding a sign. You do not acquire a First Amendment right to chain the road shut merely because your reason for doing so is political. But the sentence is interesting in the other direction. The defendants potentially face years in prison and received 30 days instead, while prosecutors dropped the most serious felony conspiracy charge after the jury deadlocked it. That gap illustrates just how much calibration occurs after we decide that conduct is criminal. Prosecutors and judges can recognize both that the protesters deliberately interfered with the rights of hundreds of other people and that they did so as part of a nonviolent political expression rather than for personal gain or predatory purposes. That is more or less how a legal system metabolizes civil disobedience. The political motivation does not erase the underlying offense, but neither must the law pretend that motivation is irrelevant when deciding how severely to punish it. On the anniversary of the Communist Control Act, it is an especially useful reminder that the legal treatment of dissent rarely comes down to a simple choice between protected and illegal. Much of the real work happens in between. And finally, TikTok and parent company ByteDance have agreed to pay $400 million to settle the Justice Department's lawsuit accusing the platform of violating federal children's privacy law, an enormous number for a case built around a statute passed before TikTok or really modern social media existed. The Justice Department filed the lawsuit in 2024 on behalf of the Federal Trade Commission, alleging that TikTok allowed millions of children under 13 to create accounts without their parents' knowledge or consent, and then made it unnecessarily difficult for parents to have those accounts deleted. The statute at issue is COPA, the Children's Online Privacy Protection Act of 1998, which generally requires online services covered by the law to obtain verifiable parental consent before collecting personal information from children under 13. There is an especially interesting wrinkle in how the $400 million settlement is structured. TikTok will pay $300 million now and another $100 million once a court vacates an earlier consent decree entered against Musical.ly, TikTok's predecessor. That matters because it is not the first time the platform has encountered the government over children's privacy. Musical.ly had already been penalized over COPA violations, and the government's latest case alleges that the problems continued afterward. TikTok is settling without admitting wrongdoing and says it has made substantial changes to its age controls and parental oversight systems. But whatever one thinks of the underlying allegations, $400 million is a fairly substantial reminder that COPA is not merely a disclosure statute sitting around from the early internet. And this case fits into the larger fight over children and social media from a somewhat different direction than the addiction and product design litigation we've been following. Those cases ask what platforms may design for children and what harms those designs may cause. COPA asks the considerably less glamorous but foundational question that comes before all of that. Who gets to collect information about children in the first place and on what terms? $400 million suggests the government still thinks the answer matters quite a bit. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcast. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, one who breaks an unjust law must do so openly, lovingly, and with a willingness to accept the penalty.